button on Zoom to ask your questions. And after that, there's going to be a 10 minutes closing remarks by one of the co-authors of the paper as well. And if you run into any tech issues, I encourage you to reach out directly to me or to Darlene English, who is one of my colleagues assisting us with these presentations. And with that, I'm going to turn it over to Brad Blower, who is going to give us a brief opening remarks. Brad, over to you.
Thanks, Michael. Appreciate it. I guess my role in this webinar today is to provide a little bit of context about what we're talking about. I'm the founder of Inclusive Partners, which is I consult with nonprofits and financial institutions on fair and sustainable access to products and services. And I had previously worked at the DOJ and Federal Trade Commission and the Relman firm on civil rights and consumer protection issues, among other places. So our discussion today really involves different approaches to the search for less discriminatory alternatives, including the ways that we design and implement artificial intelligence and models. So why is this important? I mean, first and foremost, it's about treating people with fairness and finding less discriminatory ways of lending, underwriting, fraud prevention, marketing, servicing. It's just the right thing to do. And it's fundamental to providing products and services in a fair way. And as Americans, I think we expect that we don't want to have a different outcome based upon what our gender is, what our race, ethnicity, religious preference, other protected class. We expect that whether we're denied or approved for a loan or what kind of interest rate we get will not, the outcome won't be determined based upon what demographic group we're in. And that depends on, intent is not an issue here. It can be a neutral policy if it has we don't want to be treated to have a different outcome based upon how a model or AI or algorithm is used. So whether it's the use of particular data that might be biased in a certain way or models that might be skewed against certain demographic groups, we now have the ability to really design, implement, and monitor for disparate impact in a way that we have not had before through mathematical models and other statistical means. So that's the first reason that why searching for less discriminatory alternatives it's the right thing to do. Second, it's the law. Whether there's a less discriminatory alternative is part of the disparate impact analysis that's required by the two primary fair lending laws, the Fair Housing Act and the Equal Credit Opportunity Act, and its implementing Regulation B. And every court that's heard the issue, including the Supreme Court, as it relates to the Fair Housing Act, has said that you can bring a disparate impact claim under the Fair Housing Act, and the appellate federal courts have heard the issue, have said you can do the same under the Equal Credit Opportunity Act. So just going to drill down for a second on what the law requires in terms of disparate impact analysis and how the search for less discriminatory alternatives fits into that. So basically, if a financial institution has a neutral policy that has a significant disparate impact on a particular demographic group, that institution it must have a legitimate business need for that policy that cannot be achieved by a less discriminatory alternative. And the final part of this legal test is what the panel today is primarily focused on, the search for less discriminatory alternatives. And particularly with the advent of AI and complex models, financial institutions are increasingly in the ability to really use and determine very accurately when a customer is likely to default on a loan. And so they can make predictions far more accurately on who is eligible, who would qualify for a loan or for a product. And with this increased power comes a responsibility to ensure that there's not disparate impact. So as Michael alluded to, disparate impact has very much been in the news of late, maybe not in a very constructive way. The Trump administration issued an executive order on April 23rd entitled Restoring Equality of Opportunity and Meritocracy, which sounds very good in concept, but it's actually a very strict and constraining view of what is discrimination. The Trump administration essentially believes that you can only have discrimination when it's intentional and not the result of a neutral policy that leads to significant differences in outcomes. But one thing I should be really clear about with this executive order is its impact on the state of the law, which is zero. The laws have not been changed, both the Fair Housing Act and Equal Credit Opportunity Act have not been amended. Regulation B has not been changed yet. And so there is an obligation for institutions to follow a disparate impact framework when they're offering financial products. And although the Trump administration is not going to be enforcing disparate impact, private plaintiffs and states are going to continue to enforce the laws. And even when I've had private conversations with examiners at the federal agencies, they're still going to be asking questions of institutions where they're seeing significant differences in outcomes. And they're going to be asking institutions what they're doing to search for disparate impact and the ways that they're searching for less discriminatory alternatives. So one other point I wanted to make in setting the table here is there's often an attempt by some in politics to conflate DEI with compliance with the fair lending laws, and they're really quite separate. So there's really not an excuse that, look, because of the anti-DEI posture of the Trump administration, you don't have to comply with the law. That's absolutely, an institution would be misguided in making that decision. And I find in the institutions that I work with, all of them are continuing to have rigorous controls in place, looking at disparate impact and searching for less discriminatory alternatives. So I should also mention the third reason, in addition, it's the right thing to do and it's the law, why, sorry, the search for less discriminatory alternatives is important today. It's also good for business. And I've written on this issue over many years, working with banks and financial institutions and nonprofits, that if you can qualify a larger group of people and be less exclusionary in your policies and the way that you're offering your products, that's good for your business. And particularly in our diverse society, it's going to be very important if you're going to have a sustainable business to be able to have a large group of people that you can lend to and use the technology that we have in a responsible way to be fair to them. And in some of my work with the National Community Reinvestment Coalition's Innovation Council, that's a group of stakeholders of not only fintechs, but advocacy groups that found common ground over the last 7 or 8 years to really propose responsible ways of looking at disparate impact and less discriminatory alternatives and trying to work with the government and setting standards that make sense for those propositions, for that process. I'm not the only person who's written on this, obviously. Steve Hayes, our moderator of our panel today, and his partner also at the Relman firm, Tara Ramchandani, recently wrote some blogs on why the search for disparate impact and maintaining a framework is very important for not only growing your business, but also for identifying ways that your company might actually be disparately treating its potential customers or customers. And so recent efforts by the administration, I should note, have really, although they de-emphasized enforcement of disparate impact, and in fact have tried to dismantle disparate impact. The EO I mentioned earlier actually does one other thing that I think is important that we consider, and that's it's actually encouraged federal agencies to go back and look at existing investigations and even settlements that have already been entered into that involved the disparate impact theory. And so just last month, the Department of Justice moved to vacate a settlement that it had entered into with Patriot Bank in Tennessee, a redlining case. And that case was settled in January of 2024. And in that case, the Biden administration, the Justice Department alleged that this Tennessee bank, Patriot Bank, had been redlining Black and Hispanic communities in Tennessee and entered into a settlement with that institution. The Trump administration last month went into federal court and successfully vacated that order. And the one point I want to make from this is not so much what the Trump administration did, it's what the bank did in the wake of the order being vacated. The bank had already paid out its redress to the people who had been disparately impacted by its policies, but it continued to maintain its monitoring of disparate impact. And there was a story in the Washington Post on June 1st, which discussed the Trump administration's attempts to dismantle disparate impact. And in that article, the Post mentioned that Patriot Bank was continuing to look for disparate impact, to do searches for less discriminatory alternatives, even in the absence of a court enforced order, because it was good for business. And this was an institution that had to be dragged kicking and screaming to enter into a settlement initially, but it was continuing to do the monitoring because it made sense, it was the right thing to do, and it was the law. So in conclusion, today's panel was really incredibly timely. I think we all need to step away a bit from the noise about DEI and wokeness and really concentrate on what the law says. These laws have, as I mentioned, have not changed. Responsible financial institutions and housing providers consider the Fair Housing Act and the Equal Credit Opportunity Act to be fully robust and in place. And it's necessary that we foster sound fairness principles, including the search for DI and less discriminatory alternatives. And with that, I'm going to turn it over to the moderator of our panel today, Steve Hayes, for a discussion of LDAs and disparate impact. Over to you, Steve.
Well, I think first,
Uh,
actually, Hannah's going to present some of the key findings from the paper that NAFA recently.
Thank you so much, Steve. And Brad, thank you so much for the overview of why search for LDA is the law. And regardless of the noise that we're seeing, especially at the federal level, those who are using AI, machine learning, or algorithms to make decisions that are consequential in housing and lending are required by the law to search for less discriminatory alternative. That said, I'm going to turn it over to Anna Samad, NAFA's AI governance researcher, who happens to be the lead author of the paper that we're going to share the key findings from the paper titled Introducing a Relational Framework for Less Discriminatory Alternative Search. And Anna, over to you.
Oh, lovely. Thank you very much, Michael. And I wanted to say great remarks, Brad. I think they were very critical in setting the table, and I'm excited to kind of get into things. So like Michael mentioned, hi everyone. I'm Hannah Samad. I'm from the Office Responsible AI Lab. And preceding the wonderful panel that we've managed to gather today, I'm excited to present some of the core insights from our most recent paper that proposes a new approach to LDA searches under disparate impact. The work, to provide a little bit of context, really started as a question about like what makes a model fair. Our study looked at sought to revisit a previous study that was produced by Lean Floridi to fairness scholars that made the case that fairness had to be assessed relationally because actors and different institutions have different constraints, they have their own goals, and they have their own data legacies. It turns into a more practical question of, well, that's great, but how do you actually find or assess a model ahead of time in high sector domains such as like lending or housing? So the goal of what we produce is a framework that demonstrates how we can operationalize LDA search upstream in the model development process, where choices can still be made and before harm occurs and before costs and liabilities become a burden. So with that, Brad gave a really great kind of intro to things, I think. As he kind of mentioned, disparate impact kind of covers all these domains. And with that, there are 3 prongs to that. The one that we're most interested in today is the third one, which is the less discriminatory alternative aspect of things. Regulatory bodies, as well as financial institutions, there's been guidance out there that suggests that financial institutions have to search for less discriminatory alternatives in the models and uses that they have for AI. With that, the machine learning community has kind of linked that to a particular phenomena within the literature. There's the idea that for a particular task, several different similarly accurate and performance models are able to achieve the same result with differing levels of fairness. What this means for disparate impact in particular is, well, if we know for a fact that there are less discriminatory algorithms out there, then it then becomes a duty to search for them within the financial sector. And this has kind of been talked about within the literature and like how exactly do we take this imperative and turn it into methods and operationalize it to make sure that we can actually, from the theoretically infinite amount of models out there, how do we find the less discriminatory algorithm for our particular use case? With that, the most current version of that right now is what we call a vertical LDA search. What you can see on the screen right now is this is an example of one model family. Random forest is what it's called. The way vertical search works is within a particular model family. As you can see, each of the dots represents a tuned model. This is where different features of the model or different aspects of it will be tweaked. And so it essentially constitutes different versions of the same model. Each of these iterations might have different levels of fairness. And so the goal here is to, as you can see with the gold star, find within tens of thousands of models and versions of the same model the candidate LDA. That's how it's worked before. With this, it's very useful as a methodology. It's very powerful. You can scan it and you can find notable performance differences and fairness with this method. However, using this exclusively as your LDA search means you're inherently committing significant investment upfront into one model, which does constrain the fairness ceiling that you can achieve with a particular model family, for example. It assumes that you started with the right family and you're optimizing within it at all. But the question then becomes, what if you didn't? What's interesting about where vertical LDA search lands on the model pipeline is it lands towards the end of things. So interventions, as compliance teams probably know, they'll deploy an algorithm and then somebody notices that disparate impact exists. And then you begin the frantic search of trying to find a version of that model that is less discriminatory. With that point in development, you've already produced something. It's costly to redevelop. You have to run a lot more versions of the model, tens of thousands perhaps. And so it's really late in development to not really involve some degree of liability. But as I've kind of mentioned previously, as the research in machine learning and AI in general has shown that if factors, for example, performance, accuracy, and fairness are considered in initial model development, you're able to find a model that's able to satisfy each of these criteria without having to compromise on, for example, business utility or harm on minority or underserved communities. So currently, we're starting late in the process where we might be optimizing within a suboptimal model family. So our question was effectively, if this is an inefficient and costly process and stressful process for all parties involved, then why is it the one that we're defaulting to? Our paper was really interested in asking how less discriminatory algorithm search can be reconceptualized as a more relational, context-sensitive process that more accurately reflects the development process and sector-specific deployment constraints. In other words, is there a way to surface LDAs earlier in the process of development before harm occurs and before liability becomes present? With that, we looked across and we found the idea of horizontal search. As you can see, each of these boxes represents a particular model family. This is what I was mentioning earlier. It's basically the high tier. Before you get into any of the tuning, before you begin tweaking, it's just the base level of the model. Each of them has different structures that mean they perform differently. And within that, horizontal search takes this idea and as we'll show later in the presentation, fairness variation doesn't occur just within the model, as we've been looking at with vertical searches, looking at different iterations of the same model. It also exists when you compare model families themselves. So before you get into anything computationally intensive, you can actually find fairness variation between the model families. So horizontal search takes that idea and it leverages it because this means that this is a more resource efficient step for any institution that's selecting a model. The act of model selection is in fact a fairness level. So the way a horizontal search works is the idea of first, we take the idea from Lee and Flaherty of a relational trade-off idea. So as they kind of mentioned, fairness is relational. And that's going to mean that the goals that a business has, the sector that they're deployed in, and what their constraints are going to differ. So for example, a business, for example, a lender will want to maximize their returns. They'll also want to minimize harm on particular communities. They might, if they're a small lender, they might not have access to huge amounts of compute. So with each of these goals identified, maximizing the most amount of value, minimizing the most amount of harm, we document these, and then we're able to conduct a horizontal search with the stated goals that an organization has to do the comparison on the base model family. Using these goals, we can plot effectively what you're compromising in picking one model family over another. So you're initially selecting a model family that is fair by default. You're selecting the LDA from the onset instead of punting it later down into the pipeline. So what this ends up looking like is this. Vertical search, as you can see, is after you've already deployed the model. You're tweaking something that you've already selected. You're assuming that the model family that you selected from the beginning is the right one, and you're tuning within it. With horizontal search, you're scanning the breadth of model families that you were considering beforehand, and you're doing comparisons against your stated goals to plot where that falls in terms of the goals you've articulated. So before you put in a lot of resources into it, you can do a quick cheap scan at the beginning. And I will mention that this step does fit into existing development workflows for model developers. They do perform this similar test for model families and how they perform for fairness and accuracy. So really, we're just suggesting that you also include fairness at this step, and it'll save you a lot of headache, and it'll save you a lot of time and energy to already have established an LDA and documentation for it before you begin any intensive processes. So kind of at a glance, this is some of the approaches, like what this means. Vertical LDA search, as we mentioned, downstream, it's more reactive, it's costly, demanding, and it does complicate compliance because you're already in trouble, you're in hot water already. With horizontal LDA search, this is upstream, it's more proactive, mirrors existing workflows, etc. And it does provide a documentable, auditable search process. In terms of our methodology, as I previously mentioned, we revisited a study on mortgage lending conducted by Lee and Flaherty in 2021, and the original data study used 2011 data. And it argued, their argument was essentially this real world, real outcome approach to fairness. Instead of looking for the theoretically absolute fair model, we're looking for what makes sense given the context and how fair it is compared to material impacts on people's lives. For lending, this means how many people get loans, the amount of loans they're able to qualify for. So looking at fairness in terms of how it affects people. They had 6 assumptions to simplify some of these dynamics that they ran it against, and they tested it against 5 model families on 6 common industry fairness metrics. As I mentioned, they plotted these model families against expected loan value and denial rates for Black applicants. So expected loan values is your utility, it's what you're hoping to gain from it, and denial rates would be your harm in this case. What we did for our study is we revisited this with 2021 home mortgage disclosure data from the data, and we kept the assumptions the same. We did add one assumption, assumption 7, as you can see in the paper. And we used this approach that I've mentioned, articulating your goals, and then using that as the means for comparison and plotting the model families and assessing the variation between them to guide the horizontal LDA search. So for us, we kept the axes the same in guiding it. And what you'll see in the next page is this does produce documentation in terms of being able to tell exactly what was traded off. As you can see from the plot here, with the same accuracy, we're able to see that holding everything constant, the features, everything's the same, the data is the same, the features are the same. We're able to see that the effect that model family choice has on, for example, the expected value of loans and the denial rates is material. So Picking random forest, for example, which you'll see in the top right-hand corner, will give you one of the highest denial rates, but it also gives you the highest returns. For other algorithms and model families, you can see that they kind of tend towards the medium as well as kind of median denial rates. And some, in choosing, for example, NV, Gaussian naive Bayes, this basically has the same denial rate, but it has much lower utility. And so what we can see is that model family structurally can impact fairness before you get into tuning, which makes it an interesting lever for fairness and LDA searches beforehand. This is kind of at a glance what the longitudinal analysis looks like. In both cases, you can see that there's structural variation in terms of model families and where they land. And we can expect that this behavior is more of a structural thing inherent to the model family itself, rather than the data or anything like that. Now, what this means for how we approach LDA searches and how we look at fairness. Model family selection at the very beginning, upstream in development, is an underutilized fairness level. What we can see is that for a long time, we've attributed the fairness processes with high cost downstream approaches. Where finding or adopting an LDA is kind of restricted to a model family that may or may not be the best fit for the task at hand, but we have to tweak it and we have to work with what we've got. The shift we can make with this framework is that we can make sure that you're picking the family that maximizes fairness, accuracy, and performance from the onset. You develop that from the onset instead of testing and building your model on a broken foundation. That's the nice thing about model multiplicity and the theory that has kind of emerged in ML as like a well-accepted framework. For horizontal search with a relational trade-off approach, as we've outlined, it makes it very easy to prove that a less discriminatory alternative exists and surface it. This doesn't require an institution to already have like exotic tools or like a team of PhDs siloed working on it. It can be done by any institution, from a small city department to a large lender, for example. It is a framework that is able to assess the selection process. And as I mentioned, it's more of an upstream approach. And for regulators, this presents an interesting opportunity in terms of what LDA searches can be reasonably expected, as the approach that's mentioned with model selection being the lever is achievable by even small to medium-sized enterprises or resource-constrained actors, which does raise the bar, I think, on fairness that we can expect to see in civil rights domains. As you've seen previously with some of the plots that we've demonstrated, this is a very visually easy document to navigate, which makes it really great for auditing, for stakeholders that might not, or stakeholders and decision makers that might not be technically literate, to clearly see what they're trading off in the process in terms of utility versus harms, the amount of loans they can expect to have returned on versus the denial rates. And the relational trade-off framework at the beginning makes these goals that are stated clear and sensitive to an institution's context. And for developers, it does, as I mentioned, mirror existing workflows that they would perform for fairness and accuracy. Overall, that's kind of the presentation. This approach, by incorporating fairness from the beginning, we can maximize returns, financial inclusion, and accuracy simultaneously, and provide proactive LDA justification, reducing the liability that comes with realizing your model is non-compliant far too late. I will mention the study was conducted under a set of assumptions, as I previously mentioned. So obviously further replications of the study in other sectors are encouraged, but the signal that this represents with the structural variation in fairness is clear. That model family choice is a fairness lever that we cannot afford to ignore. I've listed the co-authors' emails here if you have any thoughts, questions, or inquiries. And the paper is here as a QR code, as well as a 3-page brief, if you're not interested in tens of pages of work. Yeah, I think we'll pass it back to Michael, and I'm excited to get into the plan.
Yeah, thank you so much, Anna, for sharing highlights of the paper, visually explaining the two major contributions about differentiating vertical search from horizontal search, and then also highlighting the key assumptions on which the the research was based. And at this time, I'm going to invite our panelists to join or lead the conversation about the implications of the key findings that Anna shared for housing and also lending, and then also how feasible it is to implement the horizontal LDA search, especially for mortgage underwriting and also pricing, the regulatory and policy considerations that need to be in place for organizations that are looking forward to implementing horizontal LDA search. So first, I'm going to invite Dr. Emmanuel Ogundimu, Associate Professor at Durham University, United Kingdom, and followed by Sasha Sandberg Champion, NAFA Special Civil Rights Council, and followed by Miranda Bogen, Director of AI Governance Lab at the Center for Democracy and Technology. And the panel is going to be moderated by Steve Ace. I'll say our own Steve Ace, partner at Roman Colfax. Over to you, Steve.
Thank you so much. Thank you, Hannah, for presenting that. Thank you, Michael, and Nafa and Brad for the great introduction. I thought this was a great paper. I'm very interested in it. We'll try to save some time at the end for questions too. So there is a question and answer Q&A box at the bottom. If folks put in questions, then we'll try to get to some of those towards the end. But let me start, Sasha, with you. I know you've got deep expertise in disparate impact law generally, even outside of a model context. And I'm curious, as a lawyer here, was there anything specific that jumped out to you from the paper with respect to kind of thinking about disparate impact generally?
Yeah, thanks, Steve, and I'm delighted to be here. I thought the paper actually implicates some rather fundamental questions about how disparate impact law is going to work, both in the courts and as a matter of public policy, and specifically what we mean when we talk about the search for a less discriminatory alternative. And it really does it in a concrete way by showing how much more effective that search can be if it's front-loaded, rather than if you confine your search for a less discriminatory alternative to sort of trying to retrofit or make changes at the end. And that's an interesting question that really moves us. We've had this threshold conversation for a very long time as to whether a less discriminatory alternative search is required. And that's sort of bogged down the conversation. And I find this really interesting in terms of moving us forward and saying, okay, let's assume it is required, as NAFA certainly would advocate, both as a matter of law and as a matter of policy. So what does it look like operationally? And I think this is very concrete in talking about the choices that we now have to make about what that means and what the impact is. To me, and it does it in a really stark way, in a way that I haven't seen. I actually haven't, in my years of practice in this area, I haven't seen a whole lot of discussion at a theoretical level of what it means, what's on the table when you're looking for a less discriminatory alternative. How transformational can that potentially be? As opposed to sort of nibbling around the edges of a big picture decision that's already been made. There are a lot of cases and policy choices that sort of allude to that question. Let me give you an example of what this makes me think of. For example, there are a lot of cases in the employment context regarding the use of written tests to measure competence for employment. And those tests have been, in many cases, proven to have a disparate impact based on race or other protected class. And the courts and the policymakers have actually moved beyond just saying, okay, let's have a better version of the written test. Let's see if you can edit that test and make it so the test doesn't have that kind of disparate impact based on race. Instead, I think they've asked a more fundamental question, which is first, if you need to have a test, does it have to take this form? What about an oral test? Would that accomplish everything you need? And then more fundamentally, do you need to have this kind of test at all? Is it achieving anything? So it's certainly in the employment context, courts and policymakers have not hesitated to ultimately push on the sort of core question of what are we doing here? Why are we going in this direction? Um, but which and that's why I'm very excited. This paper sort of is having us to sort of taking us down that road with respect to thinking about a less discriminatory alternative in the context of these models, because it's one thing to say, as you know, many lending institutions do, and as regulators have required, that you test the finished product and then you sort of retrofit it, and you debias it in the various ways that everyone here has heard about. But that's only going to get you so far. And you think about, like, for example, if you it's like the question of, if you choose a car to start with and you choose an SUV rather than a sports car, you could do some retrofitting at the end, but you're still not going to optimize for speed. So the initial choice you made is going to put some limitations on how far you can get. And I think this paper has demonstrated that, which is really exciting. It's not just a theoretical sort of intuitive point. It's now one that we now have proof of, that initial choice has consequences for the sort of limitations inherent in how far you can go and finding a less discriminatory alternative. So I think that's really exciting. And the last thing I would say is I really appreciate the point that Hannah made at the end in the final slides, which is emphasizing how this is going to be cost effective, and it should be easy and should fit within the existing workflows and processes that complex organizations and even less complex organizations have already started developing. In my experience, both inside and outside of government, this is not ultimately a logic question. It's a question of whether something is fairly straightforward to do in terms of our courts and regulators ultimately going to require this to be done. And I think that's the next step, is to really nail that down, that this is something that can very readily be done, that there's sort of off-the-shelf answers. And so I'm very excited to see this kind of research move forward and see if we can get something's nailed down to the specificity and ease that ultimately is going to be required for courts and regulators to require it. Thank you.
Yeah, that's great. And I really do agree with the exercise of trying to move this into a more concrete sphere. And I think the paper is helpful in that respect. And Miranda, maybe this next one goes to you. I know that you've worked in companies on model fairness issues. I've learned a lot from you from that perspective. And I'm curious if there are any barriers to implementation that you can help identify given your experience.
Yeah, thanks, Dave. What's so interesting about the paper is that it speaks to something that's very intuitive, which is that earlier in the design process of anything, the earlier you are, the more likely that your choices will have outsized impact. Because as you move down the development path, there are fewer and fewer choices you can make to dramatically change what it is you're building. And so this is, I think, demonstrating that you take a step upstream of the choice of model architecture, and you have a lot more options to compare between. The challenge in practice is, I think there's three things that you need in order for this particular proposal and any less discriminatory alternative algorithm proposal to work. You need infrastructure to compare multiple models, which I think many institutions do have, because that's what they're doing. You need the team to be aware that they need to do that, and for a team to know that it's their job to do that, which currently in many institutions, the task to develop models for the business purpose and the task to test them are separated for various risk management reasons. And so that's something that would need to be kind of readjusted. And finally, you need the demographic data and or infrastructure to enable testing on demographic data outside of the very, often small compliance teams that have limited access to that data only for the purpose of testing. Because a fear, I think, many people have when they're trying to navigate a lot of different risks is that it's quite sensitive data. There are very many reasons why you wouldn't want that data floating around an institution, but specifically, there might be a concern that including that data in the model development process, even if it's just for testing, might end up kind of influencing the choice of models in a way that runs afoul of kind of other concerns, disparate treatment, privacy, PR, all that sort of thing. So traditionally, it tends to be quite cabined. This is the case across many institutions, not just in the financial sector. But that's not an insurmountable problem either, at least for organizations that have a method to do demographic measurement, which most financial institutions do using imputation methods. You could theoretically build a tool that would allow teams developing models to simply measure models and receive aggregate or even extremely blunt signals of sort of order of how well they're doing without receiving granular measurements of the precise disparities across precise demographic groups that might raise different concerns. But again, that's infrastructure that institutions would need to invest in and think about, privacy, cybersecurity, et cetera, in order for them to maybe be more comfortable that a broader array of teams who are developing models for business goals could incorporate this further upstream. But like I said, at the moment, those are quite separated tasks. And so both the responsibility to do that and the permission to do that are things that I think a lot of institutions haven't merged together yet. And it would be a shift in thinking about how to do AI fairness, which I think a lot of people would like to see, because it's likely to be a lot more effective to move that upstream and to have the same people thinking about multiple objectives at the same time. But because of the tasks that they're different teams are given and the incentives that they face, they are often segmented in a way that isn't yet conducive to the recommendations here, but I think something that is very much worth pushing for.
Were there strategies that you identified that help that communication between the different teams? So you've got the developers, the testers, maybe risk people, business people. I mean, you've got so many different actors who have a stake in this. Did you see strategies that worked well?
Well, I think personally, what I saw was there's often an assumption that blending these tasks together or touching on sensitive things like demographic measurement are sort of too hot to touch. Maybe we don't want to change the status quo because there's a lot of risks involved, and that just seems really hard. So it takes a lot of persistence to kind of bring people together and imagine what might be a different infrastructural approach or an organizational approach that's needed, and to get leaders to commit to invest dollars to build the infrastructure that would enable doing this in a way that would make everyone feel comfortable. And that is something that I think different institutions have a different readiness for. But certainly the ones that understand the benefit of doing that and sort of see the evidence that research like this is generating, hopefully it will be something that they take into account, because it really does, as a business matter, streamline the work in a way that you would expect. But it, let's just say organizational changes are themselves disruptive, and so it's not just the technical question or just saying actually this stuff should go over here now. This would be a pretty substantial change in how banks think about this. But again, I think it's the direction a lot of people are looking to, just as understanding of effective fairness and non-discrimination approaches continues to evolve.
Yeah, and in addition, I mean, we talked a little bit about the substantive effectiveness benefits of moving things upstream. Are there any other benefits that occur to you in terms of thinking more holistically, starting some of this work earlier in the development process, anything like that?
I mean, one of the challenges that people often face is that there's just, again, but in the way that teams tend to be structured, what information they all have when they're making these decisions can be somewhat fragmented and lead to the decisions themselves not being terribly consistent or structured. And so by bringing that all together, hopefully decision makers can really take all of their goals into account all at once, instead of trying to weigh sort of some disparate signals from disparate parts of the organization in sort of a messy blob that's the way organizations tend to think about actual risk-related decisions. You would think that it's quite structured. The process can end up being quite structured, but the decision itself sometimes can feel like they're comparing apples to oranges, things like that. So thinking about it more holistically, I think, both it streamlines it from a business perspective, a decision-making perspective, and it just reduces the possibility that sort of game of telephone that can happen creates unnecessary barriers to finding a solution that actually advances multiple goals.
Yeah. Emmanuel, I know that you also have had some real world experience working on model fairness issues. Are there important structural aspects that you've noticed in order to accomplish this work?
Thanks very much, Steve. I think the key word here is search. So there has to be a purposeful, deliberate search for the LDAs. And in order to do this, because of the nature, it's quite important that there is documented analysis plan, right? Because it's quite easy. I mean, Anna mentioned the model development pipelines, and most of this approach could be manipulated if there are no deliberate, purposeful analysis plan that are pre-specified, to look into some of these things. They often say that there are 3 types of lies. We have lies itself, we have damn lies, and we have statistics. People can lie with data. I do have experience working in clinical trials. And as you will expect, I work as senior statistician, and as you expect in clinical trials, we don't want to say that a drug that doesn't work works. So we have to be very careful in how things are processed and pre-specified. So we do have 2 important documents in that setting. We have what we call the protocol of the study, and then we have the statistical analysis plan. So in the analysis plan, what we often do are essentially what Anna laid out. We have to think of the model of hypothesis formulation, the type of the data that is going to be collected, how we're going to pre-process it, how we're going to, select variables, and the type of models that we want to propose. Now, the reason why this is done is that we do not want a situation, where what we do is people go through what is called data snooping, that you allow the data to speak instead of having something that has already been pre-planned. Now, when we have this type of document, what is often done is that we have people that have oversight function, and they make sure that everything is in place, signed, sealed, and delivered before we even see the data at all. Now, along the line, now things could change. Of course, in life, things are not always what you might expect them to be. So if there are changes, these changes are clearly documented. And then why these things were done are also documented. And this do help when we have this documented analysis plan. And I expect perhaps in search for LDAs, this kind of things might be in place.
Yeah. At least in my own experience, we've seen some of that for regulated financial institutions. They might have some detailed model risk management documentation talking about assumptions and limitations. And then in some areas, really, it's kind of a Wild West in terms of just hunting and packing. Are there other assumptions or unexplored areas coming out of the paper that you think are worth flagging? And so folks on the call too can think about, what should we be exploring in the future?
Well, yes, Anna also mentioned this. Model is based on, analysis is based on a series of simplifying assumptions. And some of them are not, in practical terms, some of them are not the kind of things that you will have in practice. Essentially, this is what Lee and Floridi also did in their 2021 paper. So it's quite important that we look at issues around, for the future, obviously, we look at issues around data bias and what we call inductive bias. So when you look at what we've done, we made simplifying assumptions like, okay, there's no selection bias, which of course in under data, this would not be the reality. There's no disparate treatment. We do not have problem of class imbalance. Hardly will you see any model on credit scoring that doesn't have class imbalance problem. So this will always be there. And then of course, there's even one particular aspect which is quite crucial. The fact that the perpetuation of selection bias. So when you look at the data that we've analyzed, the people that were actually selected, the people that were not selected, that were not offered the loan, we do not have the counterfactual of what happened to them had the loan been given to them. So this is quite an important thing. So when you look at that part of data bias, it's quite an issue because it's like kind of an infinite loop. We have a problem of data bias, then we have the model bias. Data bias will lead to model bias. Model bias will lead to decision bias. Decision bias will generate new sets of data. And then we have this loop, in that sense. In fact, if we look carefully at Lee and Floridi paper, there were some issues we saw in their data. This is the 2011 data. And those issues were replicated exactly in the same manner in 2021 data. And this is 10-year interval that we have this kind of issues. So that's on one side when it comes to the issue of data bias. Now, the inductive bias is more of the issues that we feel that algorithms they're neutral. And when you look at the mathematical formulation of these models, there are no reasons why they shouldn't really be neutral. I mean, these are mathematical, formulation. We just have to optimize some objective function. But in reality, they are not. In fact, especially when you look at this kind of off-the-shelf algorithm that we use in the model, they are not neutral. They have inherent bias because of the nature of what they are. In fact, if we do not have such, so let's just look at two cases in the model we developed. Looking at logistic regression, for example, and random forest, they might actually give us equal accuracy. But the problem is that if we go for individual predictions, logistic regression might reject one applicant, and random forest will say this person should be accepted. So we have these two crucial issues that are not fully explored in analysis. And in fact, I could summarize this to say that we have data bias, which is like something that is starting a fire. And if one is not careful, the inductive bias will determine, where the smoke, goes to, where it spreads to. So these are key issues from the analysis.
Sasha, let me turn back to you and raise something which is, again, zooming out a little bit. Given the change in the federal administration's priorities in this area, I mean, Brad alluded to that too. What incentives do companies have to engage in this work in a serious way right now?
Well, I'll give you a few reasons, but let me start with sort of shorter term. In the shorter term, obviously this administration is incredibly hostile to anything disparate impact, as Brad said. They're frankly hostile to anything that involves government enforcers doing their work. So I think for a number of reasons, I don't think people can reasonably expect that the federal government is going to bring action against you in the next few years for not doing this. But the federal government is not the only game in town. We already know, for example, that there are states that are looking hard at this, both from the standpoint of traditional civil rights laws, the equivalent of the Fair Housing Act or ACOA, but also, new regulation that is distinctive to AI and models and algorithms that states are starting to pass laws regarding. Colorado just passed a law. I assume other states are moving fast in that direction. So that's one form of potential liability where you're going to want to insulate yourself and make sure you're making choices that you can justify. We're also seeing, we're also potentially can see private litigation under the Fair Housing Act, under ACOA. The Trump administration can't make those go away. And in fact, much of the important development in disparate impact has always come first from private litigation and only later then does the federal government jump in when that private litigation has been, has shown, frankly, that it's just correct in terms of what to do. Longer term, not really long term, but relatively longer term, this administration obviously is not going to be in power forever. I mean, it's an interesting time to have this conversation. If we had this conversation 1 year ago, 1 year ago, when I was in the Biden administration, like we're not talking very long ago, I think this would have been this paper would have had significant interest in the Biden administration as something people should talk about in terms of what the CFPB should be thinking about, what the other agencies should be thinking about. That cast of characters is going to be in government again, and it's not going to be that long. And they're going to be informed by all the developments that have happened since then. So with that in mind, and then we think about the timetable that we're on for all these things. The subject matter of this paper is not, what do you do in the next 3 weeks for a model that's under that you've developed a long time ago. It's literally the subject matter of this paper is, what do you do at the front end when you're just starting to sit down and think about how to design a model? And that's going to have implications for what your business looks like 4 years from now, when the new administration is like you are literally now sort of digging the trenches that will determine, sort of your course of action, both with respect to an individual model potentially, but even more long term with respect to your processes. You basically need to start developing those processes now if they're going to look good 4 years from now. And I think that's a lot of what Miranda was just saying and Emmanuel was just saying. I mean, there's a lot of work that has to be done to get you from here to there. And I think probably you need to start now. And I will say, as someone who has been in the government, again, not that long ago, I don't think there's going to be a lot of sympathy for people at that point, for people who say, well, we didn't bother working on it during the Trump years because we knew the Trump administration wasn't going to go after us. The question is whether you're doing the thing that is required of you under a good faith interpretation of the law as it always has been seen. And then let me just give you one last answer, Steve, to your question is, why not? I mean, as Brad said at the beginning, if you do this right, this is good for business. So it certainly doesn't hurt you. And I think it gets you way out ahead of potential risk that is both in the short term and in the medium to long term.
Yeah, and I think the federal agencies, especially in the financial space, have been a big driver of this work for a long time, with banks in particular, like depository banks, many of whom have some program set up. Like every program can be improved, but the idea of searching for less discriminatory alternatives for models by banks is really not very new. I mean, that goes back very long. The GSEs 25 years ago. But there's I think some shared regulatory expectations. So we don't have answers to every question about how it should be done, but there are some basics that most institutions do, and I think that's largely driven by those regulators. But in a lot of less regulated spaces, so once we get outside of the really banks, financial institutions, maybe some other CFPB institutions, there's not the same history of guidance or shared understanding or practice. And Miranda, I'm curious, I know you've worked in those other spaces, if you've got observations about, what's happening there. Is there some way that we can find some shared understanding on some of the tough questions, or at least have informed discussions about them?
Yeah, one of the things that was most interesting to me is the huge disconnect between people who think in terms of less discriminatory alternatives and algorithms and people who think in terms of measurement and mitigation. It's just a different mindset. And I think it does have to do with where in the pipeline it's happening. And are you thinking about optimizing a particular model that's already been developed and then choices surrounding it, or are you actually thinking more expansively? But that I think is one kind of area of connection that I think would be great to draw out in a model that I think from financial services is useful elsewhere, because it's not that you have to. I often got questions of, well, how fair does it need to be? What's the threshold, et cetera? And those questions come up in financial services as well, as you guys at Relman well know. But what's interesting about less discriminatory alternatives is not that it's less. It's just like, can you do any better than what you were doing? Because that's a little bit better than it was before. And I think that's maybe a helpful on-ramp to people, as opposed to thinking about, well, there's this gap in outcomes, and I guess we're engineers and we need to close the gap. And then they often jump to sort of band-aid solutions that aren't getting at the root cause of what's leading to those disparities. Less discriminatory alternatives also, doesn't necessarily mean understanding and unpacking all the root causes and fixing them, but at the very least, it does kind of shift the thinking into how can we be doing a little better by the people that we're serving while still meeting the goals, rather than our business goals are primary and oops, we have to like fix some things at the margins.
Emmanuel, what about, I know you've worked internationally too. Is there a broader comparative perspective in terms of how entities in other countries are doing this, or how other countries are regulating this space?
Thanks very much, Steve. I think we're working with colleagues at NAFA actually exposed me to the legal framework for discrimination and what is of importance in the US, especially this disparate impact of a thing. I think in the UK, things are a little bit different. And also, even if you start from the terminologies, you could unpack some of these things. EDI, our own E is equality. In the US is equity. So the focus is a lot more on the treatment, really, rather than the outcome. Of course, we still look for a better outcome. That's why we have to give equal treatment. But of course, we know that equal treatment doesn't often translate to the desired, outcome. So I think the key issue here is that in the UK, we do have the Equality Act 2010. And a little bit of parallel could be formed from looking at the legal framework for discrimination in the US and the UK. So if you look at disparate treatment in the US, the closest we have in Equality Act 2010 in the UK is direct discrimination. And of course, since it's direct discrimination, you could easily, prove of this. Now, the issue about disparate impact, which seems that, the search for less discriminatory algorithms or alternatives are shifting towards, to prove and to look to search for this, is kind of related to indirect discrimination under this act in the UK. And of course, when it comes to indirect discrimination, in the US, of course, we could place a number on disparate impact and say maybe 80%. We don't have such a number in the UK system. So the best is just that people could bring in some statistics to prove things, but more or less it's more qualitative. And people can easily defend this on business necessity, that we've not discriminated against, so this is just the reason and why this has been done. So this is the key challenge that we have in the UK. And on a lighter note, if I may just say this, just to show that most of these things are not currently going on as expected in the UK, like it's been done in the US. So if you look at the paper that our work is based on, the Lee and Florida paper, the two authors were actually based in the UK when they wrote the paper, right? So Lee was at Cambridge at that time, and Florida was in Oxford. They couldn't get any publicly available data to use in the UK. So they used the HMDA data to do whatever they do. If you look at all the legal framework that they discussed, it's all about the US. And in fact, there were no instance where you had a comparison with what goes on in the UK. That will show you that there's a lot of gaps when it comes to these kind of issues in the UK. And I hope with colleagues in the US, we could find a way to, to solve this.
Yeah, that's interesting. I know from some of our own work, even just the concepts of discrimination or the groups or areas or categories you might be focused on can be so different across different countries. And so coming to a shared international understanding can be very difficult, but a lot of the lessons I think probably do port over. So I know we already have some questions. I'm gonna turn to those and would encourage people in the audience too to put in more questions if you have them. But I'll start with this one and open it up to the group. It's pretty straightforward. Can you avoid doing vertical testing then? So I assume that the question is, if you really properly focus on the horizontal testing that Hannah had walked us through, and you're thinking about this through, the entire development process, can you sort of stop there and then not worry about doing those additional tweaks to the existing baseline model that we're all kind of used to?
I would say no, because it's likely that once you choose the path of the model architecture to go down, there will still be tweaks to tune the model for whatever business purpose is going on. And then you still be making comparative decisions between them. But ideally, the infrastructure you would create to facilitate horizontal exploration would be the same infrastructure that would enable you to continue considering LDAs as part of the decision-making process around which of the versions of a model within a vertical branch that you've chosen are accomplishing the various goals that a business needs to accomplish.
Yeah, I would agree from a legal standpoint. I would think that both of those things at that point are part of searching for a less discriminatory alternative, ultimately the least discriminatory alternative. Both doing the horizontal and the vertical search. I don't think there would be any legal reason why you would be okay to just do one at that point.
Yes, that's quite true. I mean, and I agree with that. I think the manner would just be that we first search horizontally, and then when we get what we need horizontally, we tune that as much as we can vertically, to meet business objectives. And I would think that would be the best way to go.
Here's another follow-up one from Lisa, actually. She says, in order to establish the first prong of the disparate impact test, you have to show that a disparity exists. So one, how large does this disparity have to be to meet the threshold? And would any level of disparity qualify? And then two, assuming the first two prongs of the disparate impact test are met, so there's a disparity and whatever's causing it, in this case, the model is serving a legitimate business purpose, how much of a reduction in discrimination is required for the LDA to be adopted? So I'll throw that out there myself, saying these are some of like the problems that have really we've all scratched our heads over to some extent for a long time.
So I guess I'll jump in and take it first. The first question of how large does the disparity have to be to trigger the disparate impact analysis, at all for the remainder of it, I think that's just a heavily contested question in every context, and I just don't know that there's ever been a clear answer or ever will be a clear answer other than sort of it when you see it. It certainly has to be of enough significance that that you think it's real, it's replicable, it's not just it's sort of an artifact of the tests that you happen to be running, and it has to be significant in the sense of it seems to matter, both the reliability and the meaning of it. Beyond that, I don't know if we can pin it down. I think the other one is easier. If it can be determined that once you've determined that. Once you've determined that there is an alternative that will cut into that, I don't think the amount of the remedy has to be fully as significant as the amount of the initial disparity that causes it. If you could slice half that off, I think a court would say that's required if you could do that in a straightforward way.
Hey, Steve, if I could add one thing.
Yeah, go ahead, Brad, please.
When I was at NCRC and with the Innovation Council, a group of stakeholders tried to work with the Bureau repeatedly and issued statements trying to get at this issue of would the Bureau come out with some guidance on either an adverse impact ratio or SMD approach, but to provide some guardrails on what is statistical and practical significance. And the Bureau really didn't touch it, even though I think staff was very interested in doing something about it. Now with the Trump administration kind of dismantling NIST and others that might have gotten to this, I think we're not going to see much in the way of guidance on disparate impact and the metrics.
I had one thought too, marrying that question, which we've all done a lot of thinking about in the paper that Hannah walked us through, is one thing that's nice about this framework is it embeds it from step one in model development. So the question is kind of written almost from a litigation perspective. It's like, when could someone bring a case and make the initial showings for that case? But what's nice about this framework is it's sort of the assumption is from the jump, you're not saying we're only going to do this if if we see a certain amount of disparity at the end of the day, you're doing the entire model development process with this lens of trying to address these problems and not saying we're only going to think about this if we have some confidence that the disparities will be above a certain level. And that's not that unusual for some institutions when they're thinking about model development. There's lots of things that they do from the jump, from a fair housing or fair lending perspective, even without having to convince themselves that, you know, they're exceeding some threshold. Michael, it looks like you've got your hand up too.
Yes, there's a question we got via email, and I just want to read it out for especially for considerations. So the question is related to recent Supreme Court decisions. It says, given the dissent of Robert, Thomas, and Alito, those are Supreme Court judges from inclusive communities, do we expect disparate impact liability to be struck down the next time a case makes it to the Supreme Court?
I have some reactions, but I'll open it up if others want to try to speculate.
I mean, the answer is you can't tell what the Supreme Court is going to do in terms of what is off the table. In theory, it should at least be settled under the Fair Housing Act, that under the Fair Housing Act, there is disparate impact liability, and that's asked and answered in inclusive communities. And in theory, at least, the Supreme Court is not supposed to revisit questions of statutory interpretation. That's now a question for Congress. That's what the law is supposed to be. Now, is that how the law is actually developing in the last few years on, you know, with the supermajority Supreme Court that's hostile to civil rights and disparate impact? You know, I wouldn't tell you to bet your life savings on it.
And from a technical perspective, I think this is an interesting sort of related topic to the division between fairness, measurement, and mitigation and less discriminatory alternatives, because I think there's an assumption that LDAs require basically saying, here's a gap in outcomes, now we must remove it, which the processes for removing it, you know, you could imagine how it might seem that could implicate changing decisions based on protected characteristics or sort of engaging in affirmative action in some way, even if that's not actually what's required. But like folks who don't dig into this day to day, you could kind of see how that logic would play out. When I think the LDA approach, which honestly is really the same thing, is measurement and then trying to kind of reduce, is in practice much more of a let's look at a variety of different approaches. And especially if you're doing it further upstream and choosing model architecture, let's look at a variety of different approaches and make some high level strategic decisions based on signals about how this might impact business and, you know, and fairness and all these things, which is absolutely exactly not the sort of direct gap closing approach that I think people fear it is. And so I think that there's a, like, setting aside what the court will do, which I'm not a lawyer, so I'm not going to try to predict, but even if I were, it seems like not a good bet to make these days to predict what the court will do. I think it's actually, in general, a path we should promote, because this is just like taking into account a variety of signals about the impact your model will have, and especially as people are looking to regulate AI in various ways or not, looking at financial services as a model. I think that's something we can learn from this. It's just, how can we change the strategic calculus further upstream in a way that reduces harm to people without kind of getting into things that people fear are kind of crossing a spoken or unspoken line.
Yeah. Well, I mean, one of the questions too is kind of a corollary to this. It's the just been asked, is there a risk of the Trump administration coming after you for doing this type of work, and how should you respond if they do?
I mean, I think I'll just continue on my answer there. I think that's why institutions take such care in the way they do divide tasks, so that there could be no risk that there's a misunderstanding that teams were kind of acting on data that they oughtn't to have, because they simply don't have it. It's such a divided task. And I think that's also, like, while it actually leads to circumstances where less discriminatory algorithm approaches, like whether they're vertical or horizontal, are harder in practice to effectuate because the teams building the models are not necessarily able to incorporate the data as directly. On the other hand, it does leave sort of a protective buffer at the moment, which might be helpful as we're thinking about this, because there is such arm's length distance. And in fact, that I think was created on purpose.
And although, I wouldn't say you have a safe harbor here, if you're an institution that has been relying on guidance from over the course of many administrations and the jurisprudence on testing for disparate impact, I think you could point to that, certainly in a court case, and say, look, we were making reasonable steps following decades-old jurisprudence and guidance from the agencies to date, even though, the executive orders have been hostile to disparate impact.
I will just also say that although this is a kind of weird thing for us to say in this room and in the space of people who think about disparate impact and believe in disparate impact discussion, that's not really how they conceptualize the world. And these models, whatever else you want to say about these models, before and after the debiasing, they literally treat you the same whether you're white or black. And that's actually what the Trump administration is that's what they're focusing on, is always perceived instances in which people are literally being treated differently because of their race, as opposed to they don't care about the disparate impact. And in some ways, that's the saving grace in terms of if you're worried about legal, they would have to depend on a theory of legal liability they don't believe in. Let me sum it up that way in order to go after you.
It wouldn't be the first time. The case against Meta was like in their housing discrimination case was a weird like a backbend of trying to kind of twist disparate treatment into a disparate impact argument. And so you never know what they'll try to do, but it makes for interesting arguments for sure.
No, I know, Michael, we're almost out of time for this piece of it. I'm gonna just ask one more question from the audience that we got, at the risk of making you mad. But is there a scenario where plaintiffs and nonprofits with a moderate amount of ML expertise can design and discover LDAs? And what kind of transparency and access to the lender's data or methods would they need to be able to do that?
I mean, that's been one of the barriers so far in all these arguments, is that plaintiffs are typically not in a position to be able to have access to all the data, parameters, choices, et cetera, that the developers do, which is what has driven the argument that the onus ought to be on the developers to be incorporating this into their process to begin with. I would think unless you had anything reasonably equivalent to the same data the company had that they were using to develop their models, it would be possible to develop like examples and arguments that there could have been a better way. But I would assume that an argument that a firm would make in defense would be like, well, that's not actually the data that we were using. And so that's not a legitimate alternative, and we can't tell us otherwise. And so that would be a gap that would need to be closed. But again, that's why I think relocating the requirement here is an argument that is coming out of some of this technical research, which is so important.
So the state law, I mean, that's like when Sasha mentioned the Colorado law, I think there's some of the legislation that we've seen at the state level is recognizing that difficulty and putting then the burden on the model developer as the entity who's best positioned to at least start this inquiry, for sure. But I'll also say, and it's true in litigation, it can be very difficult to do this, like in the abstract, yes. But then there are always low-hanging fruit type cases where something comes out about an institution using some type of information in a way that may not resonate well with a court, and that can really put that institution on its heels. And so that's not the easy, that is in a sense the easy case to say, well, prove that you have to use this information. And I think in litigation, things can develop in really unexpected ways. It's not going to be the step-by-step that we're used to seeing in compliance or what an institution might do on its own system. Okay, Michael, I ate into a minute or two. Oh, it looks like Brad wants to.
Just one last point. I mean,
yeah.
One interesting thing is that the Patriot Bank case illustrates is that I think a plaintiff or a nonprofit group could point to the fact that once they filed their complaint and the institution for the first time started to look at their own data, the absence of doing that at any point before the litigation might be a factor a court would consider. If the company had taken no steps to look at its own data prior to being approached by either law enforcement or private plaintiff.
All right, Michael, let me turn it back over to you and thank you everyone for the insights. I was really interested in that.
Thank you so much, Steve. And once again, a very big thank you to our panelists and Steve, the moderator, for engaging conversations. And one way to actually evaluate the quality of a panel discussion is the list and also the quality of questions that you receive after the discussion. So again, when it comes to the challenges and opportunities in adopting the framework proposed by the research, as well as compliance considerations that need to be in place, I hope that our audience have one or two takeaways from the conversation. So at this point, I'm going to turn it over to Jamil Khan, NAFA's data scientist, to give us closing remarks and then also discuss possible next steps. Jamil, over to you.
Thank you, Michael. My name is Jamil Khan, and I am a co-author and a data scientist, as Michael mentioned, that worked on this paper. As we wrap up today's discussion, I want to sincerely thank you all, panelists and attendees alike, for joining us to explore the future of algorithmic fairness in housing and lending. The webinar posed a key question: how do we ensure that our models not only perform well, but also uphold our civil rights values, particularly in sectors with histories of exclusion and discrimination like housing? Our discussion was anchored in the recent paper, Selecting for Less Discriminatory Alternatives or Algorithms, which proposes a horizontal LDA search framework, a practical, scalable approach to selecting algorithms that deliver comparable accuracy while reducing disparate impact. Let's briefly reflect on 6 key takeaways from today's dialogues. First, model selection is a civil rights issue. Fairness is not merely a matter of optimization. It's a moral and a legal imperative. As we discussed, finding and implementing less discriminatory algorithms is a civil rights issue. The Fair Housing Act, Equal Credit Opportunity Act, and recent CFPB guidance affirm that the need for proactive fairness testing and transparent model selection processes. Second, data science and empirical modeling grounded the work. As Sasha mentioned, the strength of this paper and this research lies not just in the theoretical framing, but in the rigorous empirical work behind it. I led the data analysis and machine learning modeling, drawing on 2021 HMDA data to train, compare, and evaluate 5 algorithm families: logistic regression, KNN, CART, random forest, and naive Bayes. Through careful feature engineering, fairness metric implementation, and race-aware versus race-blind scenario testing, we demonstrated that strategic model selection can yield measurable improvements in fairness while preserving performance. This practical application makes the framework reproducible and usable in real-world institutional settings. Third, horizontal LDA search is a game changer for implementation. As Miranda alluded to, unlike traditional vertical fairness approaches that rely on hyperparameter tuning with a single model, horizontal LDA search encourages institutions to evaluate different model families at the outset. This early-stage intervention can uncover significant fairness gains without requiring massive computational resources, a vital step for smaller institutions or teams with limited technical capacity. Fourth, fairness trade-offs must be contextual and transparent. As Emmanuel mentioned, no model is entirely equitable when all forms of fairness are considered, and that's okay. What matters is how the trade-offs are evaluated and justified. Using the relational fairness framework, organizations can align model selection and sector-specific values like financial inclusion and document their reasoning, making fairness a deliberative and accountable process. Fifth, regulatory and policy support is critical. Panelists reiterated that the necessity of clear regulations and industry standards. Lenders need to know exactly how far to go with LDA searches, which fairness aspects to consider for specific use cases, and how to gauge risks. Cooperation between the government and industries is necessary to promote fair AI practices, and wide support from both parties is needed for implementation. Public agencies and industry leaders need to join forces in aiding the transition to scale towards responsible AI. And finally, fairness can be achieved without sacrificing accuracy. Perhaps most encouragingly, the study validates that fairness and performance are not mutually exclusive. Because of model multiplicity, a range of models with disparate fairness characteristics can exhibit analogous levels of predictive accuracy. This means that the institutions can identify a legally and socially acceptable algorithm. As you leave today's session for next steps, we encourage you to review the full paper on arXiv for methodology, code references, and policy implications. Link to the paper was already shared in the chat by Michael. The presentation and recording of this webinar will be shared in a few days. Consider integrating horizontal LDA search in your model selection pipeline, especially at the initial stages. Collaborate across teams, legal, technical, and executive, to ensure fairness isn't an afterthought, but embedded in your development process. Engage regulators and peers to establish industry-specific fairness benchmarks and share best practices transparently. In closing, I want to underscore that advancing fairness in real-world system isn't just a technical challenge. It's a leadership challenge. The work to build such a foundation will require all of us to join forces, researchers, regulators, and AI developers alike. Let today's discussion be a catalyst for that collaboration. Thank you again for your time, energy, and commitment to creating a world where how you live and where you live is not determined by unfair code. We look forward to continuing this important conversation with all of you. Thank you and goodbye.